Welcome to another Working Wise podcast from K&L Gates, LLP. My name is Hayes Stover, an Immigration and Employment Counsel and a member of our Labor, Employment, and Workplace Safety Practice Group in the Pittsburgh office of K&L Gates. Today, I'm going to discuss United States Citizenship and Immigration Services, better known as USCIS, Form I-9. Form I-9 is a form that every employer in the United States, no matter how small, must fill out and retain for every new employee hire. Why should an employer care about I-9s? In all of 2017, Immigration and Customs Enforcement, or ICE, conducted 1,360 I-9 audits. Through July 2018, 5,200 audits had been conducted. A number of these included workplace raids and arrest of suspected unauthorized employees. Form I-9 is a result of legislation enacted in 1986, referred to as IRCA. One objective of this legislation was to fight unauthorized immigration by limiting employment availability. To further that goal of limiting employment, employers were required to obtain specific evidence of identity and authorization to work from each new employee, and to then record that documentation on Form I-9. The estimated 11 to 12 million unauthorized foreign nationals in the U.S. suggests the legislation did not fully achieve its objective. However, the employer's I-9 obligations continue. IRCA provides several prohibitions. An employer may not knowingly hire a foreign national who is not authorized to work in the United States. An employer may not hire an individual without complying with employment verification obligations. An employer may not continue to employ a foreign national who was authorized to work at the time of employment, but subsequently loses that authorization. Knowingly includes not only actual knowledge, but also constructive knowledge that may be fairly inferred through awareness of facts and circumstances that would lead a person by use of reasonable care to know about certain facts. The obligation to comply with I-9 regulations is separate from the prohibition against hiring unauthorized individuals. I-9 violations occur even if the new employee is authorized to work, but the employer has failed to comply with I-9 obligations. The instructions for Form I-9 and an available online handbook, M-274, provide details for completing Form I-9. My comments today will highlight specific issues and discuss the process and penalties for violations. The I-9 form changes from time to time. The current form is dated 7/17/2017 in the lower left corner. The employer must use the form current at the date of hire. The form must be retained for the later of 3 years after the date of hire, or 1 year after the employment has terminated. In preparing the I-9 form, there are several obligations. The applicant must fill out and sign under threat of perjury Section 1 of the form before beginning employment. The applicant must present either the required identity and work authorization documents within 3 business days of beginning employment, or a receipt for the application for required documents within 3 business days, and the actual documents must be produced within 90 days. The employer must, within 3 business days of hire, First, examine the documents and ensure that they appear to be genuine. And second, complete Section 2 on the I-9. Individuals who are not U.S. citizens or permanent residents are normally authorized to work for a limited period of time. Employers must keep track of those limitations, require current updated information, and record the updated authorization on Section 3 of Form I-9. An employer is not required to renew the verification of an employee who temporarily ceases work, but has a reasonable expectation of recall. An employee who transfers to a different location or unit of the same employer need not be re-verified. A related, successor, or reorganized employer need not re-verify. However, a successor which relies upon a predecessor's I-9 is responsible for any errors that occurred. More and more businesses are using contingent workers or independent contractors. Such businesses should be aware that certain I-9 obligations still exist. It is beyond the scope of this podcast for a detailed discussion of independent contractors, but in many instances, individuals deemed independent contractors are found to be employees. In that circumstance, I-9s would be required. 1996 amendments to IRCA and implementing regulations now provide that a person or entity which knowingly uses a contract or other relationship to obtain services of a foreign national who is unauthorized to work shall be considered as having hired that foreign national. No obligation exists to require or verify I-9s for true independent contractors. However, a company using an independent contractor may want to include a warranty of I-9 compliance in any agreement with the contractor. There are monetary penalties for violations of hiring prohibition or I-9 verification procedures. The procedures have an agency, ICE, Homeland Security, or Department of Labor, investigating, either based upon random selection or based on information provided by third parties. The agency does not require any warrant to investigate. Employers must produce copies of any requested I-9 within 3 days of the request. The agency may issue either a warning notice or a notice of intent to fine. A notice of intent to fine becomes final unless a hearing is requested before an administrative law judge within 30 days of the receipt of the notice. If a hearing is requested, it is held in accordance with specified procedural regulations. There are civil penalties for violation of I-9 verification, which range from $220 to $2,191 for each individual. The specific amount is determined by considering the size of the employer's good faith, the seriousness of the violation, whether the employee was an unauthorized alien, and a history of any previous violations. Civil penalties for knowingly hiring unauthorized workers range from $548 to $4,384 each individual for the first offense, $4,384 to $10,957 for each individual for the second offense, and $6,575 to $21,916 per individual for subsequent offenses. I-9 compliance is a serious and ongoing obligation that requires an and employers' attention. Every employer should consider a periodic audit of I-9 compliance by counsel. Thank you for listening. More episodes in the K&L Gates Working Wise series can be found at knlgateshub.com. You can learn more about our labor, employment, and workplace safety practice at our website, knlgateshub.com.